Miss Lewis, you have something that you submitted to us documenting something that the defendant posted on social media. Is that right? Okay, what was that?
So after the defendant was locked out, I was called by my landlord. She gave the police my landlord's phone number. He contacted me and said, hey, I messed up. We actually do need to serve a 3-day pay or quit notice before you can lock her out. Miss Hastings then proceeded to post a video on social media, basically talking about how she was going to make the last 30 days a living hell for me and my landlord. Just a bunch of stuff that I shouldn't repeat.
Ms. Hastings, you were very clear in terms of trying to submit evidence that sort of painted the plaintiff in a certain way. For example, I didn't really appreciate you sending a text to her saying that you had some gift for her when it was really a lockout. And you provided that evidence to us. You didn't, conveniently. And so I'm going to take that into consideration for me in terms of who's being honest, who is being petty, in terms of how I'm going to decide. But I'm going to open this up to my colleagues for follow-up questions.
Thank you, Judge. What about the utilities? Are you charging her for utilities in May?
So I think she should have to pay for rent and utilities, of course. The reason I think she should have to pay for May.
And how much are the utilities for April?
So the $440, that's for utilities for March electric that was never paid, April electric, April Wi-Fi, and then May electric and May Wi-Fi as well. But just for April, it looks like the electric was $72.47 and the Wi-Fi was $79.73. So she would pay half of each of those because we split. And the portion that she did not pay in March.
I have nothing further.
Ms. Hastings, you said in your answer when you tried to tender your rent to the landlord, he effectively was playing a game with you by refusing to accept it. What do you think he was trying to accomplish?
I don't really know. I don't have any reason to understand why he would want to do that to me, or maybe it was just because, as Maddie had stated from the beginning, there were issues with rent. First, it was not on the portal, then it's this, then it's that. And I understand there's issues, and that doesn't make me look like a great tenant.
Ms. Lewis, if the new tenant is supposed to make the old tenant whole for the security deposit, did your new tenant return any money to Ms. Hastings?
No, because Christy is still owed $600, I had that new tenant just pay Christy the $600 that Robyn owes her.
So your new tenant is $600 short on a security deposit as well?
Not short, I'm just not sure where that money would go. If that should go to Christy, if that should go to paying Robyn's old rent, that's still something that needs to be discussed.
Okay.
All right, we're going to excuse the parties while we deliberate in this matter. Thank you very much.
This court is again in session.
Ms. Lewis, Ms. Hastings, we have deliberated, reviewed the evidence, and reached a verdict. The verdict was not unanimous, and that is because we had a difference of opinion on one of the facts in this case, and that is whether there was, in fact, a validly signed lease. So when the three of us don't agree, the majority rules in this court, and the majority today was Judges Tewelde and Judge Corriero. They believed that there was not sufficient evidence here that there was a signed lease. They're not really persuaded that you ever did sign it. They also found that it was never delivered to the landlord, which would have been required to actually have a valid and signed lease, which would put you in California in a situation where you effectively have a month-to-month tenancy. And with respect to a month-to-month tenancy, when you receive a 3-day notice to quit or pay rent, that does not relieve you of your obligation to pay rent that you already owe for a time period that you were already there. But it does mean that you do not have to pay rent if you elect to quit the property. So for that reason, the majority decision here, which is going to be the verdict of the court, is that Ms. Hastings, you are responsible for 1 month of rent plus utilities for the month you were there, April, minus your security deposit. And all three of us agree that you are entitled to a refund of your security deposit. I would have found, had this been just my opinion, that you did have a validly signed lease. And frankly, I wouldn't let you off the hook in the way that I think you could be otherwise by claiming that you didn't sign it. So I would have found that you also, under the lease, should have been held responsible for the rent payment, but not the utilities, for the month of May. But again, my colleagues have the majority opinion of the court, and so their verdict controls. So the verdict today is in your favor, Ms. Lewis, for the total amount of $767, which represents April's rent and utility payments minus the deposit, which we all agreed you were entitled to receive back. So that is the verdict of the court, and we wish you all the best.